Hello, hello. Welcome to Crime in Court. My name is Heather, and this is another update in the Delphi case, Indiana versus Richard Allen. And he is going to be going to trial next week in the homicides of Liberty German and Abigail Williams. And that happened in 2017. We are just now going to trial in 2024. Richard Allen has been in custody almost 2 years now. So, and most of it has been in solitary confinement. He spent 19 months in solitary confinement. And it seems as though his attorneys and civil rights have been stripped away from him. And then his attorneys came back after the Supreme Court ruled that they came back to the case. And since then, Judge Gull has still had it up her craw to just basically rule in favor of the prosecution for just about everything. So that's kind of where we're at. We're going to trial. The defense has been handicapped quite severely by the state and Judge Gull by their motions in limine to eliminate certain topics from the trial, including the Odinist line of defense, where, they, in the Frank's memos, have laid out that they believe the actual perpetrators in the homicides were Odinist members of the Odinite community, and therefore it was done as a sacrifice. And they have named some names, and those names are not to be named as a third party culprit, and that was ruled by Gall. So, but as you'll see, something about that is it brings to my attention. So as we get there, I'll bring it up. So let's read through. I have a couple new filings from the defense, as you can tell by by the title of the thumbnail here. So we're going to go through this is going to be kind of a short update. We don't have a ton of filings; they're short. So let's get to it. Please hit that like button and let's begin. So the first motion we're going to begin with is the motion for order on designated defense representatives. So you'll see, but they want someone in the courtroom basically to help them with all of the evidence and, help them sort through things and figure stuff out during trial. So let's see. Comes now the defendant, Richard Allen, by counsel Bradley A. Rosie, pursuant to Rule 16 of the Indiana Rules of Evidence, and respectfully requests that this court issue an order authorizing the defense team to designate a supporting staff member to remain in the courtroom and assist the defense team in representing Richard Allen's defense during the jury trial in this cause. In support of said request, Defendant Allen states as follows. Number one, it is well known and has been previously articulated in prior filings with this court that the volume of discovery in this case is unprecedented, whether that's by design or not. I kind of feel like the state did that on purpose to drown them in discovery. By conservative estimations, the raw amount of data that has been provided by the state to the defense through dozens of discovery dumps exceed 20 terabytes. In addition, the defense has generated its own discovery as a result of its own investigations, which have been ongoing for nearly 2 years since defendant Allen's arrest in October of 2022. Number two, there also exists volumes of deposition transcripts, pretrial hearing transcripts, and various other transcripts that have been created as a result of defendant Allen's lengthy detention in the Indiana Department of Corrections. Number three, the discovery in this case involves thousands of hours of surveillance video from various places and locations associated with the crimes in question and resulting investigation by law enforcement officials. Number four, in an effort to review, organize, and access the totality of the discovery in this case, the defense has employed Max Baker to assist with this process. Number five, for nearly 2 years, Max Baker has assisted with the review and prioritizing of discovery. Mr. Baker has also become extremely intimately familiar with the technical skills needed to navigate through various media players and other similar software to access both audio and video files. So he could be an AV guy. He can help them with all of their um, examples, exhibits. That's the word I couldn't think of. All of their exhibits, whenever they're ready to play an exhibit or show an exhibit, he can help them in that aspect. Number 6, Rule 615 of the Indiana Rules of Evidence permits either party, the state or defense, to appoint a representative to assist with the trial that would otherwise be ex- expected accepted from separation of witness order. The rule further permits an exception to the separation order in a case where a party shows that an individual is essential to presenting the party's claim or defense. Number 7, in this cause, the defense team seeks permission from the court authorizing Max Baker to be present in the courtroom throughout the course of the jury trial, despite the fact that he has been identified on the defendant's combined witness and exhibit list provided to the state on October 1st, 2024. That's interesting. Why is he on the defendant's combined witness and exhibit list? He is on the defendant's combined witness and exhibit lists. Okay. Anyways, 8. Defendant Allen believes that his substantial rights will be prejudiced if he is not afforded the ability to have access to Max Baker during the trial proceedings. Such a denial would run afoul of Defendant Allen's due process rights under both the Indiana and U.S. constitutions. And 9, Defendant Allen respectfully requests that this court issue an order authorizing Max Baker to assist his defense team during the course of the jury trial and therein accept them from any separation of witness order. So because he's a witness, they want him to make the exception that he doesn't need to be sequestered or whatever. So I guess that is, I don't know why he's a witness, but there you have it. So that is, they're asking for an individual to this Max Baker to be in the courtroom near them at their table, or have a separate table in order to present evidence, present the exhibits, assist them in finding certain relevant evidence when they're looking for something. So uh, hopefully she grants that. But I mean, she doesn't have a reason not to, but who knows? She could, because it's Skull. Up next, motion for transport of IDOC inmate. And this is interesting. So this motion is specifically for James Haas, but you're going to see that there's multiple people that they have actually sent these transfers for. So comes now the defendant Richard M. Allen by counsel Bradley A. Rosie and respectfully requests that this court issue an order directing the Carroll County Sheriff to transport inmate James Haas to the Carroll County Courthouse to appear and testify at the trial in the above referenced cause. In support of the motion, defendant Allen states as follows. 1. The jury trial in this case is set to commence on October 14th. Like I said, Monday, we are starting jury selection. Number 2, the defense intends to call inmate James Haas as a witness in this case. Number 3, however, due to the volume of witnesses and due to the fact that the defense will not be able to present its evidence until the state has completed presenting its own evidence, it is somewhat unpredictable as to when inmate Haas will be needed in the courtroom. Number 4, the defense requests that this honorable court issue an order directing the Carroll County Sheriff to retrieve inmate Haas from his respective IDOC location/facility upon reasonable request by the defense. 5. Attorney Rosie has communicated with Deputy Attorney General Aaron Ridlin, who represents the Indiana Department of Corrections, and confirmed that the IDOC requires a 24-hour notice period prior to any inmate being retrieved from the Department of Corrections and transported to the Carroll County Courthouse. So we need 24 hours notice. Therefore, we would like to see if we can get them transported sooner. Therefore, defendant Allen requests that said transport order articulate the circumstances referenced above as to provide some flexibility to the defense, the Carroll County Sheriff, and the Department of Corrections in transporting said inmate in a manner that is most efficient and most effective under the circumstances. That is cited by Brad Rosie. And we also have some transfers for a Davis D. DeRicci Jr., or it's D. Davis Ritchie Jr., not really sure, but one or the other. And he's coming from Newcastle Correctional Facility, and his earliest release date is 2039. I just thought that was interesting that that's on there. So there's him. There's also James Haas, who we just read the motion for. He's in the Indiana State Prison, and his earliest release date is in 2058. Keegan Klein, who we talked about before, he was one of the original suspects. They even named him on the news. He was actually proven to be speaking to Libby. Sorry. Well, was it Libby or Abby? He was speaking to the girls. I can't remember which one now. I don't know. He was speaking to them on the phone. I have it somewhere, and I want to fact check right this second. Um, next is James Chadwell James the second. I don't know. Why is it written? Oh, maybe his name is Richie D. Davis Jr. That because I thought it was his last name first. James Haas, Keegan Klein. Yeah, so James Chadwell. Sorry. James Chadwell is the other person. So there's four inmates that they are planning on bringing, I guess. Um, Keegan Klein, he's at the Newcastle Correctional Annex, so these all need to be transferred over to the Carroll County Courthouse. And his earliest possible release date is 2048. James Chadwell is at Wabash Valley, and he is getting out no sooner than 2103. So he's going to be in prison for a little while. All of them are, but that's probably a good thing. So those are some inmates that the defense is planning to call, whether it is to impeach them, perhaps, or to impeach a state's witness about one of maybe the so-called confessions or admissions that he's done. Maybe it's to counteract those, or I don't know. But Keegan Klein, remember, he was one of the people that was listed on the state's motion in limine as to exclude his name from trial. But they're bringing him as a witness, it seems. So I guess they're not going to be. It's not to exclude their name. Sorry, I should make that correction. So the motion in limine isn't to just exclude their names wholly from trial. It is to blame the third party culprit aspect on those individuals unless the defense can bring like a full, really show cause that these people should be named. She's not going to allow it. So, but you can still bring them. You can still call them as witnesses, apparently. So they're going to be called as witnesses because they might have something that would show that, it's exculpatory to Richard Allen. So we'll see how that goes. It'll be interesting. And lastly, the defense has filed a motion in limine, and this one is interesting. Let's hear it. So the defendant, Richard M. Allen, by counsel Bradley A. Rosie, moves the court as follows. 1. Defendant Allen is charged with 2 separate counts of felony homicide pursuant to the Indiana rules, the Indiana statutes. Number 2, defendant Allen has reason to believe that the state of Indiana may seek to admit at the trial of this cause testimony from various prison guards, inmates, law enforcement officers, and possibly the testimony of other IDOC state staff members as to defendant Allen's mental state during his detention at the Westville Correctional Facility and the Wabash Valley Correctional Facility. Remember, he was transferred from one to the other. That was about last year, I think, like around December time. He was transferred to Wabash, which was much farther away from any of his attorneys. At that time, his attorneys had been stripped from him per Judge Gall, and he had different public defenders assigned to him when he was transferred to Wabash. And they weren't quite aware yet of all the intricacies of this case, and they had not noticed, the whole 19 months in solitary confinement and what it did to him. So they weren't ready to fight that at that time. They weren't able to fight that at that time to get him out of solitary or closer, nearby to um, his family and his defense team. Anyways, all right. So the defense believes the state's offering of said testimony will be driven by their desire to use said guards, inmates, administrators, and law enforcement officers to establish the veracity of alleged incriminating statements made by defendant Allen. 3. The specific individuals have been identified on both the state's witness list and the defense witness list. So we've got lots of multiple witnesses. Whoops. State and defense witnesses, which are exchanged between the parties prior to the filing of this motion. So the defense shared those specific names, but he's keeping them private. The defense desires not to list each and every witness in this motion as to maintain some confidentiality, taking into consideration the public interest in this case and the forthcoming trial. So he's being very careful here not to throw out names because Judge Gull would not like that. The defense will offer up the names of said witnesses at a hearing on the motion or upon request by the court, whichever applies. Defendant Allen believes that such testimony would violate Rule 701 of the Indiana Rules of Evidence. The witnesses do not have sufficient life experiences that would permit making judgment as to the mental state of defendant Allen on the dates and times in question or on any date and time before or after Richard Allen's arrest. Number 5, said testimony would violate Rule 702 of the Indiana Rules of Evidence as the prison guards, inmates, law enforcement officials, and some of the administrators have no expertise in the field of mental health. I believe this wholeheartedly. They have no expertise in the field of mental health and therefore are not qualified to draw such conclusions. Only experts in their field are able to draw conclusions legally on the stand. Otherwise, you can give an opinion, but it should be weighted less than an expert, I would think. Same here. So the witnesses don't have sufficient life experiences to judge a mental disorder. So again, they're not experts. They don't have the life experience nor the professional experience. Said testimony violates 704 of the Indiana Rules of Evidence as the testimony amounts to the witness drawing an opinion on an ultimate issue. For example, whether or not the witness believes the defendant Allen is guilty of the charged allegations. I believe if they are not an expert, they should not be drawing an opinion. 7, finally, said testimony, or a conclusion, I should say. 7, finally, said testimony would also violate Rule 403 of the Indiana Rules of Evidence as it tends to be confusing and misleading to the jury due to the lack of expertise in the field of mental health. Exactly. You might think oh, he's a prison guard, so I respect his word more because he's in a position of authority. But that doesn't mean that people in positions of authority don't lie all the time or come to conclusions that they don't have the expertise to back up. So you really have to be careful in this manner in who can provide an expert opinion, especially when it comes to mental health. So that's a biggie. And I posted the other day on my ex account that, Richard Allen was in solitary for 19 months. That can cause all sorts of disorders, mental health disorders. And anyone who spends over 15 days in solitary is more likely to develop said mental health disorders. So he's been in 19 months. Let that sink in. That's almost 2 years he's been sitting in a prison or in a prison cell by himself with very little human contact. And the human contact that he was getting were people, I think, heckling him and telling him, that he should just confess and tell everybody that he did it. That's what I think happened. Number 8, such evidence is not necessary for a full and fair determination of the facts in this case. All right. So, and that is the final motion from the defense. That was the motion in limine. Basically, we want to exclude the guards, inmates, administrators, and law enforcement officers from talking about any kind of conclusions that they've come to regarding Richard Allen's mental health and or his guilt or innocence regarding that. So, I think I think it's a really good motion to have put forth. Whether or not she okays it is another thing, but they put some good arguments here. I mean, maybe they could have gone more in depth as to like who an expert should be and but and how they are qualified. But in this case, I think it does the job. It just explaining like m- the people that they're trying to bring forth to give an opinion on Richard Allen's mental health or mental state really have no expertise or experience and should not be giving that kind of conclusion. I agree in that regard. I think only mental health professionals should give diagnoses and opinions on others regarding their mental health state, especially on the stand. So we need to have rules. We need to follow rules. We need to have limitations. So I gotta go because my dog is staring at me. I don't know if you guys can see her. Let me, now you move your head. There's her nose. She's just staring at me. Like, come on, get off. You've been out long enough now. Put your head up. No? Okay. She wants to go. They all want me to take them out, so I gotta go. Thank you guys so much for watching. I appreciate it. I appreciate you just for being here, supporting my channel. I know a lot of people talk about the Delphi case, but here we don't like to speculate unless, we have some clear evidence or, what am I trying to say? We don't like to speculate and we go through the court documents and come to our opinions and conclusions from there. We're not experts, but we're not in the court of law. We can come to our own opinions and conclusions. She's still staring at me. She's not going away. Aw, look in the camera. No, she's not going to do it. All right. Anyways, bye. Thanks, guys. Thanks for watching. Please hit the like button on your way out. I'll talk to you guys later.